Good evening and welcome to our candidate forum for tonight. My name is Monica Lavold. I'm going to try to turn so I can see all of you a little bit. Hi. And I'm the director of Friday Memorial Library right here in New Richmond. The library is proud to sponsor this forum as we believe that civic and community engagement is a core pillar of library services, and that connecting our community with information in order to make decisions is fundamental to what we do. In addition to our commitment to community engagement and access to information, we provide materials and programs that educate and offer recreation for all members of our community. As many of you know, we are building a brand new library here in New Richmond. Our building is under construction as we speak. So if you haven't seen it, just down Arch a few blocks, you will see a building under construction. And we actually anticipate being in that building later this year in a brand new state-of-the-art facility. It will be 3 times larger than our current facility. If you aren't familiar, it is the site of the old middle school and community commons, right next to the center. In this new building, we will feature a larger collection and many spaces for people to sit, either quietly or alone or in groups. We will have dedicated spaces for teens, children, adults, and multiple meeting rooms of various sizes. I would also encourage you, if you haven't visited your local library lately, to go and check it out. Libraries are doing wonderful things to sort of help with this community engagement. Here in New Richmond, we offer a library of things collection. You may not realize some of the things we do, including Roku devices that you can check out for up to 2 weeks, each coming with a different streaming platform subscription on it. We offer monthly Crafty Adults programs where you can try your hand at DIY and tap into your own creativity. And we have regularly scheduled unique events for kids like a science and sensory lab every Monday, or our monthly kids karaoke night, which is actually happening right now across the street. So if you want to be in a different place, kids karaoke. As we start here tonight, I really want to give a big thank you to the League of Women Voters. You may have seen a few of them in t-shirts walking around, and they really helped us get set up tonight. League of Women Voters is a nonpartisan organization that encourages active, informed participation in government. They have a lot of information at the door or in the hallway and are here to answer any questions about voter registration or voting in general. We are going to say the Pledge of Allegiance very shortly. Before we do, I want to give a very quick thank you to the City of New Richmond, the Hudson Star Observer, and River Channel for their work in making this event happen and promoting it so that all of you could be here tonight. So to everyone who helped make this happen, please know that we're so grateful for you. And now we will stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Now, as to the structure of the event, my assistant, Patty Van Neville, is both a member of the library board and is active with the League of Women Voters, and she will be using a timer to ensure that all statements are kept to the time limits. She will hold up a yellow card when you have 30 seconds remaining. She will hold up a red card when your time is up. When you see a red card, you must stop talking. Candidates should not interrupt or talk over each other, and you will all be given equal time to speak at tonight's event. Candidates will each be allowed to make a 3-minute opening statement, and the order of this was predetermined randomly. I will then ask questions as the moderator, and each candidate will be given no more than 3 minutes per question. After each candidate has had a chance to answer, there will be an opportunity to open the floor for any rebuttals. Rebuttals will be limited to 2 minutes. After 90 minutes, we will try very hard to keep that to 90 minutes, we will end the questioning period And at that time, candidates will be able to make a 3-minute closing statement. Again, the order was predetermined randomly. We will not be able to take any public questions during this forum. During the forum, we also ask that you silence all cell phones or other devices, refrain from clapping, cheering, booing, making obvious faces or gestures that may interrupt the candidates or disturb the conversation and process. All questions will be asked, then we will have a rotation in order that candidates will be answering first different questions, if that makes sense. So, okay. Questions from the candidates. We good to go? Okay. Our draw at the beginning of the night for opening statements, we will begin with Heather, followed by Jamie, and then Brian. So, your 3 minutes starts now.
Thank you for the opportunity tonight. My name is Heather Amos, formerly Heather Holsky. I have lived a majority of my life in St. Croix County, growing up in Hammond, graduating from St. Croix Central High School in 1997. Went to college in Duluth. After graduation, I got my first job with St. Croix County as a legal assistant in 2002, and I attended law school at Hamline University on the weekends while working my full-time job. After law school, I was hired as an assistant corporation counsel for the county. The corporation counsel office is the county attorney for the county, handling all civil matters. I worked that job until 2002 when I was appointed as the head corporation counsel. My experience is primarily in the civil area, handling anything from mental commitments to children in need of protection and services, guardianships, contracts, zoning, a variety of union contracts, and so it goes on in terms of the civil experience I have. For 16 years I've practiced law, so I don't have quite as much experience as my colleagues next to me, but the experience I do have is directly relevant to the role of judge. And that's because I have 22 years total of experience working for the county. I understand what county services are available to those individuals that appear before the judges. I have experience with working with behavioral health and adult protection, the county board, answering complex legal questions that the county board may have. Writing resolutions and ordinances is part of my main job now, besides giving legal advice to the various county departments. So I believe my experience and knowledge in that area will be perfect and ideal for the next judge for St. Croix County for Branch 2. And on a fun note, I am married to my husband Lance. Together we have 2 adult children. We have 2 dachshunds that bark at everyone that walks by our house. And for fun, we like to golf and go on warm weather trips. And thank you again for having us tonight.
Wonderful. Jamie.
All right, thank you. Good evening. My name is James Johnson, but most people have known me as Jamie. I want to thank the city and the library for putting on this forum. As a candidate, I offer my legal experiences and life experiences to serve this county as its next circuit court judge. My life has been dedicated to pursuing justice and fairness and serving other people. I've been a lawyer for over 37 years, and during that time, I've had experience with the circuit judge position from several different perspectives. My background starts with being raised on a farm in rural Wisconsin, developing the values that come with hard work of daily chores, milking cows, and putting up crops. And I believe that lifestyle instilled the discipline and drive that allowed me to excel in academics. I graduated summa cum laude with a double major in criminal justice and political science at Carthage College in Kenosha, Wisconsin, and graduated with honors from Wisconsin Law School in Madison. I was selected to intern on the Wisconsin Supreme Court, and I was appointed to a judicial clerkship for the 3rd District Court of Appeals in northern Wisconsin. I served as a criminal prosecutor in Langlade and Eau Claire counties before coming to St. Croix County, and that included 24 criminal jury trials. Since 1990, I have been in private practice representing a wide variety of clients, individuals, families, farmers, small business owners, large corporations, employees, employers, elders, and minors. I made shareholder in my firm in 1997, and during my career, I have resolved well over 2,000 cases of all types, including civil, criminal, and administrative, and I have examined hundreds and hundreds of people under oath. More important than results in a particular case is that I am most proud to have earned a reputation for honesty, integrity, and candor. I've been asked to serve as an unbiased, neutral third party to help people fairly resolve their disputes outside the courtroom in both mediation and arbitration. I have volunteered to mediate over 100 small claims cases for St. Croix County that would have otherwise required court resources with a trial to resolve. Outside of my legal service, I have served my community by volunteering and leading in many varied ways, serving at Bethel Lutheran Church, the YMCA, Hudson Boosters, the Christian Food Shelf, Community Cable Access, Hudson Daybreak Rotary, and the Hudson School District. The latter includes being elected to 4 3-year terms to the school board and serving the last 11 years as president. These life and legal experiences give me the background to serve effectively as your next circuit court judge. I pledge to serve with integrity, dedication, and hard work while giving respect and fairness for all and administering nonpartisan justice. Thank you.
Thank you. Thank you for having us. My name is Brian Smestead. I'm the Deputy District Attorney for St. Croix County. I've been practicing law for 27 years. I've lived in St. Croix County for 22 years. I live in Baldwin with my wife and my 2 sons. As the Deputy District Attorney, I am frequently assigned to the most complex and serious cases involving crimes that are committed in St. Croix County. I handle cases like homicide cases, attempted homicide, sexual assaults of children, all the most horrific types of crime, and other less horrific types of crime. That's my daily job. I'm in court every single day. My entire job is litigation. What I'm doing is prosecuting criminals who've committed crimes in St. Croix County to keep our community safe. That's what my life is right now. Prior to becoming the district attorney, I worked for the public defender office in Hudson. And you may think that's a weird transition, but how that happened was I had an office. I was in private practice for 15 years, had an office in Baldwin, handled every type of case you can imagine, family law, did some bankruptcies, criminal defense. But as time went on, I decided that I wanted to devote my entire career to public service. And that's when I joined full-time with the public defender office in Hudson. As a public defender, we represented folks that could not afford attorneys, that were charged with crimes in St. Croix County, Pierce County, Dunn County, and Polk County. Me personally, I represented hundreds, if not thousands of folks in my years at the public defender's office, including through homicide jury trial. Everything from disorderly conduct to the worst possible crimes you can imagine, one of which occurred right here in New Richmond. I eventually was promoted to the attorney manager for the public defender's office in Hudson. I supervised a team of attorneys that were doing that kind of work throughout western Wisconsin. In 2019, I was offered a job by then District Attorney Mike Nieskis. We had done a homicide trial together. After that trial, he offered me a job. At that point, I was ready for new challenges, and so I accepted his job, and I've been with the District Attorney's office ever since. As I said earlier, I handle some of the worst cases that come through. If any of you watched the Apple River stabbing trial, it was nationally televised. I was one of the prosecutors for that, and other cases just like that. In court every day. I'm with all 4 judges every day. When I was at the Public Defender's Office, I served on the County Community Justice Collaborating Council. I know all the issues. I know all the procedures. I've been practicing for this job for 22 years. That's why I'm the best candidate. Thank you.
We will now move on to questions, and I will read the entirety of the question, and then I will call you back in the order that you will answer that question. So question number 1, judicial philosophy refers to the lens through which judges interpret and apply the law, their underlying ideas and beliefs which shape their rulings on particular cases. How would you describe your judicial philosophy? And we'll start with Brian.
Thank you. Well, the first, the first and most important thing is that judges should not be changing the law. The judges have to follow the law as it's written, and we have to apply that law to facts that come into court. We do that through trials. We do that through evidentiary hearings. We can't have a judge who's going to come in and say, well, this is an issue that I care about. This is why I want to be judged, and then make judgments based on that preconceived notion. That's not how the job works. So I guess what I would say is that you got to know the law, you have to follow the law, and there's no wiggle room for putting in your own personal opinions and beliefs when you're doing that job.
Thank you. Jamie?
All right. With regard to judicial philosophy, I would say that I'm neither an activist nor a total restraint. I think that it would be judging every case on its own merits, but the primary role of the court is to apply the law as it was written, not to create the law. So I am definitely not an activist philosophy in that inventing words that aren't there. I would apply, I guess, sometimes they call that a textualist, as get into technical terms, but the text of the law is what you focus on. And it's only in those cases where the way the law is written and being considered in the factual circumstances that it has would be ambiguous. And then you would resort to constructing what did the legislature intend by that law. But without ambiguity, there's not a reason to be finding intent that's not there. As judges, we can't make up the law, we only apply it. And that's a big difference between the trial court and the Supreme Court or the highest appellate court, where they're doing much more policy-driven decisions. Judges put their own biases aside and need to just apply the law as it was written and giving fair opportunity for everyone to be heard so that you're trying to apply the law to the truth.
Thank you. And Heather?
And I would have to agree with both of the candidates. I actually had to look up what is judicial philosophy to see what was out there about the different terms that people use to describe how judges make decisions. And as the candidates have indicated, being nonpartisan is the primary way that the judges should rule. Judges should rule based on the facts and the law that are presented to them and not impose their own biases, their own personal opinions when making those decisions. When I was doing my research on this issue, a lot of people use the terms liberal, conservative, or moderate. And again, I think those terms should not be used in the terms of judicial candidates. As we run on a nonpartisan platform, politics should not be involved in our judicial candidacy or when we take the bench. I think that it is important for democracy and the three branches of government to ensure that the judicial branch remains nonpartisan, that decisions are made based on the law and the facts. I agree with Jamie that I would consider myself a textualist. Whenever I render opinions to the county board, I make sure I'm reading the plain language of the statute, Wisconsin Constitution, the United States Constitution, in order to make my decision and opinion for the county board. I think that's very important for judges to do, not to impose their own bias or personal feelings into their decision, but basing it strictly on the law. I also think that it's important for checks and balances to know that the legislature and the executive branches, they make the law, and the judges are to enforce those laws or to make decisions, and maybe a judge interprets the law and indicates it's unconstitutional, but that is for the judge to determine based on the actual words in the Constitution or the statutes.
Thank you. We will move on to question 2. Do you believe judges with a variety of personal and professional experiences can better understand the needs and respect the interests of the community they serve? And are there any particular personal or professional experiences that you have which you feel are unique or make you stand out from the other candidates in this election? And we will start with Jamie.
Very good. Yes, I do believe very strongly that a variety of personal and professional experiences help you understand the community. And that's why for nearly 35 years, I've embedded myself in the community, through service, various organizations, and also I ran for school board, and I think that that stands out as an experience that prepares me for making tough decisions. Being on the school board, you get lots of different issues that come forward, and you need to put aside the biases, and you need to bring down the temperature in the room, and you need to do what's best for the students and the taxpayers when it comes to the school board decisions. I've even had to serve and preside over, I think it's 21 expulsion hearings where we've had to expel a student. Not something that we like to do, but again, you give them fair opportunity, and then you end up rendering a decision for the whole board. But I think that's another experience that's quite unique and gives me a different perspective on judging others, if you will, but again, not something that's easy to do. But I think the other area is mediation, as far as professional experiences that make me stand out. I have served as a mediator. Other attorneys have come to me and said, you are fair and impartial. We want you to serve as this neutral third party to help us come to a resolution. And so I'm proud of the fact that attorneys who have actually opposed me are now supporting my candidacy because they see me as somebody who has had a broad range of life experiences and legal experiences and can bring to the table things that will make the decision just and fair. And they know that I will listen well, because that's what you have to do as a mediator in order to get two parties to agree to a resolution.
Thank you. Heather?
Yes, I do believe that judges can better understand the needs of the community based on their personal and professional experiences. As I indicated, I grew up in Hammond. I know the county well, working in public service for 22 years. I've gotten to know the communities and what each community has their own values and different things. So from Hudson to Ceylon to Forest to River Falls, each community has a different perspective on things. Rural farming communities, the more urban, I'd say City of Hudson, all those things are important for a judge to understand the different areas of the communities within the county. I also think there's particular personal or professional experiences that are unique to me, I say would create empathy. I'm a first generation college student. I was a single parent for several years, which is why I worked full time as a legal assistant and went to law school on the weekends. I understand because part of my job is to deal with people who are having mental health crises or abuse and neglect of elders or children being placed in foster care, that when people come to court, it's oftentimes the worst time of their life. They're convicted of a crime, or they need some mental health treatment, or their children have been placed in foster care. And I think the experiences that I have had in my life, I can understand and empathize with them, knowing as a judge, I still have to base my decision on the facts and the law, but understanding that when a person comes to court, it may be one of the worst times of their lives. And so just making sure that they understand what is happening, especially if they're not represented by an attorney, explaining what is happening in the courtroom in a layman's terms so they can understand. So I do believe that those personal experiences and my professional experiences working in public sector for 22 years, my hopes is I can continue on in the public sector as the role as the next judge.
Wonderful, thank you. And Brian?
Thank you. So as far as personal experiences go, obviously, I mean, we've been in St. Croix County since 2003. My children born here when they were younger. My wife and I coached T-ball. We made connections with folks in the community over in Baldwin where we live. My older son played hockey for many years. I was a hockey dad. We ended up doing tons of work to support the Baldwin hockey program, Blackhawk hockey, charity drives, everything you can imagine. And through that process, you end up meeting a lot of people, and it's a good experience. One of the things that I've been doing recently, and probably for about the last 8-9 years, is we've been having groups of students come into court to watch, to learn, usually for intake court or for other types of things. So Judge Needham and myself, sometimes other folks, will address the students, and we'll have question and answer period. They're typically Baldwin students, but sometimes Hudson students and other folks. So we try to make the students understand the process. We're always trying to recruit kids to go into law or court reporting, which we badly need. So those types of experiences, I think, are very valuable, and you make a lot of connections with kids in the community. As far as professional experiences, I'm the only candidate that's been a private bar attorney, a public defender, and a prosecutor. When I was a public defender, as I said earlier, I represented indigent folks, people that had nothing, that were determined to be indigent by the state financial guidelines, that needed help, and they had no one to turn to. And like I said, I represented hundreds of those folks, and they came from all walks of life, all possible creeds, colors, religions, languages. A lot of times there was language barriers that we had to work around. So those types of experiences really give you a perspective on life, a perspective on the law and how it applies to folks that don't always understand the process or what's happening to them. And then as a prosecutor, I mean, my experience is keeping the community safe and making sure that victims of crimes are reimbursed for damages if they suffer a property crime, and making sure that folks that commit horrendous crimes are off the streets. And those experiences for the last 5 years, I think, have been invaluable. I know I've made some enemies in this community, folks that I've put away, and that's too bad. But there's not everybody can walk the streets. So I think that those experiences have made me a person who will be able to handle both sides of the issue as a judge. I've got defense attorneys that support me, that are endorsing my candidacy, and prosecutors. And I think that for a person in my position, that's fantastic. It means that people know I can be fair, and I think that I will be fair when I'm elected. Thank you.
Thank you.
So I have, I just wanted to add a couple things that came to me after the other two were able to answer. So when it comes to dealing with people, indigent people, or people who maybe can't afford attorneys, I had experience doing that when I was a prosecutor. There are a lot of people that were pro se, who maybe made just enough not to qualify for a public defender, but they didn't make enough to hire their own attorney, and so we had to work with those people. But just my own personal, growing up in rural New Glarus, Wisconsin is where I went to high school, in a small town. And I had 4 brothers, and my folks didn't make a lot of money. So we would probably, under today's standards, my family would have qualified as free and reduced lunch. But I know what it's like to hard work, and I can understand those experiences. And so then when I became an attorney, one of the things that I did was volunteer my time to give free legal advice through the local bar association. And I've done that for off and on for a couple decades when they needed people in different areas of the law, giving advice to folks and pointing them in the right direction.
Thank you. Do either of the other candidates have a follow-up for this question?
No.
Thank you. So we will move to question 3. Make sure I don't have to. Many Americans believe that judges don't set aside their personal political beliefs for making rulings, and thus, while the position of judge is nonpartisan, the election of judges has arguably become more politicized. Wisconsin's most recent Supreme Court election in 2023 was the most expensive judicial race in history, with over $45 million spent. What role do you feel judges have in preserving public trust and confidence in the judiciary? And we are going to start with Heather.
Thank you. So I touched on this a little bit, but I do not believe politics should play any role in the judiciary. And so judges do have a responsibility, or those candidates who are running for judge, to preserve the public trust and confidence in the judiciary. I can tell you, while I've been campaigning and door knocking, that's the question that often comes up. Are you Republican? Are you Democrat? And explaining to individuals that judges are nonpartisan and should be running on nonpartisan platforms is probably the question I get the most. And I think the hard part is we're currently going through a Wisconsin Supreme Court election. The 2 candidates running are very much on opposite sides of the spectrum. And I think $5 million+ have already been raised between the 2 of them, and so it's very political in the Wisconsin Supreme Court race. And I think it's important for us as candidates for local circuit courts to ensure that politics don't play a role in this election. I think it's very important for judges to ensure that the public understands that as a judge, you need to remain impartial. You need to treat everyone that comes before you the same, regardless of their race, religion, gender, political ideation, and that everybody has the same standard when they come to court, and that no one is treated special because they're wealthier or they're a certain race. So I do believe that judges play a very important role in the candidates running for judge in making sure that the public knows that this is a nonpartisan race and politics are not involved.
We will then move to Brian.
The way that you, as a judge, preserve public trust and confidence in the judiciary is by doing a good job, by being fair, by being impartial, by showing it every day on the bench. I can't think of a case that I've had in St. Croix County with any of our current judges or the judges from past years where politics played any role. It's not something that happens. Our judges are all very good at putting aside any beliefs they have, listening to the evidence, listening to the facts, and rendering decisions based on the law. And that's why, that's how you preserve public trust. And that's the kind of judge I'm going to be. There's not going to be any legislating from the bench. There's not going to be any kind of judicial activism. You're not going to get a break if you wear a certain type of T-shirt in my courtroom. You're just not. So that's how you preserve the trust. You walk the walk, and you show people that you're fair and impartial.
Thank you. And James.
Yes, well, prior to running for this position, I've talked to the judges and how they run their courtrooms and what their philosophies are and so forth. Plus, I've obviously practiced in front of all of them as well. But, in their chambers, they have confided that that's one of the areas that they have great regret is what's happened at the Supreme Court has given kind of a bad name for the judiciary at the trial court level, because at the Supreme Court, you've got candidates running and indicating how they're going to vote on issues. You cannot do that at the trial court. You have to decide every case on its own unique facts and the law that's provided to you, not the law that you want it to be. And so I very much believe that partisan politics plays no role. I've been running for this position. I've probably knocked on 1,500 doors in 8 communities in this county already, and that's one of the most frequent things. People come to the door and they say, okay, which party are you? And then I have to explain, it's nonpartisan. I'm not a member of any political party, and I have to be a judge for all. Now, some of those people answer, that's the right answer. And there are others that kind of cock their head and just wonder, well, wait a minute, what are you trying to hide? It's not that I'm hiding anything. That is the truth. That is what we need to do. And I've demonstrated that as well on the school board, is putting aside partisan politics. I'm not sought any endorsement from any political party. I don't think that has any place in trial court races or circuit court judge races. So I strongly believe that we need to preserve that public trust by staying impartial, nonpartisan.
Thank you. The floor is open for any response or rebuttal, if any of the candidates would like to make.
No.
Okay. We will move on to Mr. Bomer. Can you tell us about a recent state or federal court ruling in which you feel a wrong decision was reached or which you disagree with? And we are going to start with Brian.
I'm not going to answer that, and this is why. Because judges have to make decisions based on the evidence in front of them. So as you're reading a decision, you don't know the whole story. You don't know what witness testimony they listened to. There might be a summary of it, unless you have a transcript. You're not going to know what exhibits were presented, what arguments were made. Judges need to listen to each case on a case-by-case basis and make their decisions. So for any judicial candidate to get up and say, that was a wrong decision, they don't know the whole story. And they're judging their opinion without having the whole story, and that's not what a judge should be doing.
And while it might sound redundant, I agree with Brian. It's hard to sit up here and second chair or second guess a decision by the state or federal court when we do not know everything that was presented to those individuals. And so to second guess a decision that was made by either our Wisconsin Supreme Court or the United States Supreme Court would be disingenuous, because I don't know all the facts. I don't know what they reviewed, the transcripts or the arguments or the testimony. So I agree with Brian that we should not be making an opinion about that. And so that is my answer.
When you run for a position like this, you get different questionnaires, and there was actually a questionnaire sent to us that had a similar question about state or federal decisions, and it's not as applicable for the trial court or circuit court because, again, they're making rulings to interpret laws, usually on a constitutional level, that decide policy, based on specific facts, but still overall. Sometimes I heard a saying in law school is that hard facts make bad law. And so when you get a case where there's very sympathetic, it looks like it's really one-sided, that's a tough area. Judges at the circuit court level aren't making those laws, So anyway, the case that, if there was any case in recent time, I would say the decision that involved the VMI, the Virginia Military Institute, ended up being, I think it was a 7-1. Not sure why it was 7-1 and not 8-1, but there's 9 U.S. Supreme Court justices. And I think that decision, the fact that there was only one dissenter, showed that in the basic ruling of the court was to recognize equal rights for women. And so it's something that I think was long overdue. There's lots of decisions over the years that you can point to that aren't so recent, but I think that they corrected some wrongs, whether that's race relations or whatever. So I would say that decision was one that I would agree with, and I would say one that where you can get consensus despite conservative or liberal is probably a good decision.
Thank you. Would any of you like to make any response to anything?
No.
Wonderful. Moving on to question 5. Law enforcement and the judiciary are both parts of the criminal justice system, and they work together to uphold the law and protect the public. What can a judge do to ensure a positive yet fair and impartial working relationship with local law enforcement agencies? And we will start with Jean.
Well, I think when you're a judge, you're called upon for a specific role, and you're, in addition to applying the laws we've been discussing several times, you're also deciding the credibility of a witness. And law enforcement officers are no different. Now, some people that you see on a repeat basis, they build reputations and so forth, but I think the law enforcement, when I was a prosecutor, I had a good relationship with law enforcement, but it's not the same. Judges are going to, they have to be deciding people's credibility, so that includes witnesses, and so there's got to be some separation there. But judges certainly can do things like do ride-alongs with law enforcement. I think that kind of builds trust so that judges get appreciation for what the officers do. When I was a prosecutor, I did ride-alongs. In fact, one police officer was my brother-in-law. He actually introduced me to my wife, and but he would take me on multiple ride-alongs, and I think that's one thing that's a good experience for judges to see, frontline what it's like, gives them perspective, but they can do that in a way that they can still remain fair and impartial. And I think judges also stay in the community, whether that's working with or around law enforcement agencies. There's drug education programs that judges are involved with, and work alongside law enforcement to do those things. So I think that's important as well.
Thank you. We will go next to Brian.
Thank you. So in my job, I work with all of the various law enforcement agencies daily throughout the county. from reviewing police reports for charging decisions, reviewing search warrants, modifying search warrants for the judges to approve, doing testimony at preliminary hearings, motion hearings, trials. I work with our law enforcement daily, and we are very, very lucky to have a very a good set of officers in this county. We don't have a lot of issues with that they get in some bigger cities with, improper procedures and things like that. But as a judge, you do have to have the guts to point out when an officer makes a mistake. And sometimes when I'm reviewing warrants, I'll tell an officer, well, you need to change this because this is something that's not right. So you have to have a good relationship with the officer. You got to have the guts to tell them that you made a mistake. If you need to throw out a case, you throw it out. I mean, that's the way it goes. But I should tell you this, I have many law enforcement folks supporting my candidacy, and one of them recently remarked to me that he never thought that a former public defender would be supported by law enforcement in our community. So I think that just, it shows that even the defense bar, the cops, everybody knows that I'm going to be fair and impartial, and that's why I have support from very different groups. But, maybe they won't like me when I'm judge and I rule against them, who knows?
Similar to Brian, I work with law enforcement probably every day in my job and have for the last 16 years. A lot of the cases that we handle in the Corporation Counsel office, we do work with local law enforcement. I oftentimes provide training to them just so they're up to date on the laws that they may not address as much as they do the criminal cases. And law enforcement has a lot of standards that they are required to follow now. Obviously, in the last probably 10, 15 years, mental health issues, substance use issues have increased, and so law enforcement is required to know a lot of areas of the law and to deal with all types of people. And I think judges need to understand that law enforcement plays a role in the community, same as social workers and other individuals that may come before them as a witness, and they need to determine their credibility, treat all law enforcement agencies and officers the same, making sure that they are doing their job when they're testifying in court, presenting evidence. And if a judge doesn't believe that the person is credible or that the burden hasn't been met, then the judge will dismiss the case. But I think it is important to remain positive with the officers, make sure you keep a good relationship, because you might get a phone call at 2 o'clock in the morning from an officer needing a warrant signed. And so just making sure that there's that professional relationship with the officers, but still being respectful and understand that they have a role in our community and a job to do.
Thank you.
I'd like just to add something. So in our office, we do get calls at 2:30 in the morning to help with warrants and things like that. And what I hope that the community understands is that how difficult the job is for these officers out on the road, because we've got, some of them are younger, less experienced folks. They put their lives in danger every day, and people, I think that they kind of roll their eyes at that. But if anybody remembers what happened to Katie Leasing here, these officers' lives are in danger, and so I think we should remember that.
Thank you. Any other statements? Thank you. So we will move to question 6. Do you believe it is important for judges to be engaged in their communities? Why or why not? And if elected, what would your existing level of engagement in the community change, and if so, how? And for this, we will start with Heather.
I do believe it's important for judges to be engaged in their communities. I think it's important for the communities and the citizens to know that judges are people. And so we have things that we like to do. I support Coco's Heart because I like dog rescues and I like dogs. But I think it's important for judges to be engaged in the community and let the community know that we are here serving the citizens. As a judge, I want to make sure that the communities are safe, and whether that's, deciding to put someone in jail or prison, making sure victims are compensated and protected. I think it's important for judges to be in the community. So if elected, I do believe my level of engagement in the community would change. I would like to be more involved in the community than what I am right now. I think, watching Shop with a Cop, when the law enforcement officers go and take underprivileged kids out for shopping for school supplies, having judges involved in that, just letting the community and the kids know that judges are just people too, and we want to see them succeed. So I do think it's important for judges to be engaged in the community.
Thank you. Jamie.
As I explained before, I've been involved in the community for over 3 decades, and that would not stop when I become a judge. Judges should not live in ivory towers. I think that they need to be part of the community, and because it's important to witness firsthand how the laws are affecting the citizens and society, and just get kind of the temperature of the community, so to speak. I personally would remain active in my church. I would remain active in Rotary, and I would remain active in the YMCA. I see Judge Waterman there almost every day, and so I would continue doing that. However, judicial ethics do require that you refrain from fundraising. So it's something that I've raised thousands of dollars for Rotary, and chaired 2 capital campaigns for my church. That would have to, I would have to withdraw from doing those type of things. But I think I can support my community in lots of different ways besides fundraising. The one area that I can't serve anymore would be school board, and that was the decision. I thought 4 terms on school board was enough, and I will not be doing that whether I win this position or not. I won't be serving on school board, but it won't stop me from serving my school district, because even as a judge, you can put on educational programs, you can go into schools and lecture. I did that back when they actually had a thing called driver's ed in schools. Now it's all outsourced. But I would go in and give a lecture once every semester. And then in addition to going into the high schools, I also lectured at the University of Minnesota, and judges do that as well. In fact, judges can teach classes because my best friend is a judge in Minnesota, and he has taught at the University of Minnesota, I think, for many years, almost all the years he's been on the bench. So I would welcome those types of opportunities, because working with youth and education has been a passion of mine even before I was on school board.
Thank you. And Brian.
Well, I would continue, obviously, my programming that I do with the students that come to the courthouse to watch court. I mean, I started off doing that as a public defender, and then they kept me on when I became a prosecutor, and I suspect I'd still be asked to speak to students if when I'm judge. But one thing that I do want to do, and I can't do it right now as a prosecutor for conflict reasons, but I have a lot of friends in this community that are combat veterans. And we do get combat veterans that come through our court system. And as a prosecutor, I can recognize the issues that they have: mental health issues, PTSD, drug and alcohol issues, anything you can imagine. We, for years, have been trying to figure out ways to help these veterans, make it up for their service. And I know our judges now typically ask every defendant that comes in through intake court, are you a veteran? So that we can try to identify those folks early on. What my idea is to set up what I call a veterans mentor program. And I can't really do it as a prosecutor because I'm prosecuting these folks, but speaking to other friends of mine that are veterans around the county, I think we'd have some volunteers that would do it. And basically, it would be based on a program that I think Sheboygan County had started, and then there's also a program in Missouri. And what they do is they train folks to how to be good listeners to veterans who just need a friend and someone to help them, make everyday choices, such as, when you have court, getting you to court if you need a ride, helping you get to your mental health appointments, getting to your VA doctor appointments. And I think that we have veterans in the community who are willing to do that. And I've personally talked to a few, so that's something that I want to look into and hopefully make some strides towards. We tried to do a veterans treatment court. We didn't have enough people to make it viable. Treatment courts are expensive, this is years and years ago. But this program I don't think would be expensive, and I think that the county probably would listen to me as a judge if I made a proposal. but it would really be more of a volunteer, just helping out, veterans helping out fellow veterans. So that's a program I want to get involved in.
Any other comments on that? That actually leads really well into our next question. So moving to question 7, what are your views on mental health and drug treatment diversion programs? Would you like to see any changes to the existing diversion programs available in St. Croix County? And we're actually going to start with Brian.
Well, I work with our diversion programs every day. We have treatment court for drug and alcohol issues. We have diversion programs for folks that are first-time offenders or low-level offenders. We have programs through the county for mental health treatment, but for years and years, we've been trying to get more. It's a huge issue in this county. We don't have enough resources. For example, and Heather knows this probably better than anyone, if we get someone that has a Chapter 51 emergency commitment situation where they have to be put into a hospital, they typically get driven down to Madison or Winnebago. I mean, it's hours and hours away, and we have to use an officer to make that transport, and that takes the officer off the street. And it's excruciating for everybody involved, because then we got to bring them back for their first hearing and then potentially bring them back for a second hearing. We need a mental health treatment facility in St. Croix County. And we talked about that when I was on the CJCC committee years ago. We tried to figure out some way to make it happen. We would bring in folks from various hospitals and see if they'd be willing to, pitch a program for their hospital. It's just nothing's ever happened with it. And I get that it's expensive. But as a judge, I think our judges have been advocating for that for years. And I would continue that advocacy because it's absolutely essential. We used to have a hospital in Cumberland where we'd send people. That's been shut for a long time. We used to be able to send people to Amory. We aren't able to do that anymore. Sacred Heart in Eau Claire, they don't take folks very often, if at all. So it's absolutely essential that we figure out some way to get more mental health, a facility here where we can send people on a temporary basis so that they are, can get the help they need, but also can come back to court easily enough. I did hear recently at one of our judges' luncheons that they are starting Hazelden is opening an alcohol facility here in Hudson, or over in Hudson. So I don't know much detail about it. Sounds like it's going to be a facility with a number of beds, and that's going to be very useful for us. We do have options for AODA programming, more than we do for mental health treatment. And one of the other things that we struggled with, and have for years in this county, is why can't we access the programs over in Minnesota, send our folks over there so they can get treatment, because it's very much way closer than going to Madison or Winnebago. And for whatever reason, and I hear many reasons, we just can't do it. I don't know why. It seems like a silly law, and that should be something that should be addressed so that we can send folks to facilities that are way closer that can help them out. So.
Thank you. Jamie?
Sure. Well, the question is, what would you like to see? Changes to existing diversion programs? I don't know that we have to change what we currently have. We just need to utilize them more, and we need more of them. Diversion programs play a very vital role in criminal justice. I heard a saying, an ounce of prevention is worth a pound of cure. But what you can do is, when you're going to the root cause of some of the crimes that are being committed, whether it's mental health or drug treatment, you take them out, you save the taxpayers lots of money by doing that. It's a very cost-effective way. It promotes fairness and equal treatment. It increases public safety. It reduces harm and improves quality of life. And it comes down to effective use of resources. And I've seen firsthand the treatment court that Judge Nordstrand runs. It's a very good program. I was privileged to watch a graduation of someone who was in there. Now, different diversion programs are for different things. Our treatment program is geared to people who have already been down the road quite a ways in multiple contexts in court, felonies, serious drug offenses, and so forth. But getting their life turned around is incredibly important, rewarding, and again, saves the taxpayers. So I think we need to use more diversion programs, and I agree that having a facility closer than Winnebago, which requires incredible amount of resources to send 2 deputies across the state to take somebody in and then come back. We pay lots of overtime to do that. We need something in western Wisconsin, no doubt. And that will probably then increase the ability of diversion programs to function, but it's really outside the diversion programs themselves. And again, we're talking about, on a lot of them, it's pre-charging diversion, where you're looking at somebody who hasn't had contact with the courts yet, trying to prevent them from being recidivists. Mental health, my wife is a behavioral psychologist, and whenever we see something on the news, she always wonders, well, what's the real root of why somebody did something? You know, what's going on in their background? And that's something that I see our judge is doing a good job. And it was, I give credit to Judge Black for coming forward when he did to get the treatment program going, treatment court, drug court, they call it for short, drug court going, because it's been a very worthwhile thing in St. Croix County.
So I think that both mental health and drug treatment diversion programs are very necessary. Obviously, our district attorney's office runs diversion programs throughout their office. We also have treatment court. And for low-risk offenders, I think these diversion programs where they can offer a deferred judgment of conviction so that someone who is low risk and wants to make sure they don't have a criminal record can take the steps, get the treatment they need, or meet other certain conditions as part of their deferred judgment of conviction, so they can hopefully not have a criminal record. And it's all about making sure they're rehabilitated so they can be part of the community, they can be a taxpayer. I also think that treatment court is very necessary. If you ask the jail captain or the sheriff how many people in the jail have mental health or substance use issues, it's probably more than 80%. Recently, the county did fund for 18 years a behavioral health specialist in the jail to help address some of those mental health and substance use needs. And I believe that's been very helpful. That's been paid for through opioid settlement money. So that has been a plus for the county. I also think that one change I would like to see to existing diversion programs is something that recently came about in the county. Our Children's Services Division, with the approval of the circuit court judges, applied for a 3-year grant. It's $125,000 per year to try to start up a family treatment court. And so family treatment court would be to help those parents who have children placed in out-of-home care, such as foster care or with a family member, to get the treatment they need to have their children placed back with them. And if I'm elected as the next St. Croix County judge, I would love to take on that task if the other judges would allow me to. I think it is half of our children in need of protection services cases, more than half, involve people that have a substance use issue or a mental health disorder that they really need the treatment for. And because of either finances or education level or just overwhelmed with being a parent, they're not able to get that treatment themselves. They need someone to hold their hand and tell them where to go, what to do. I really think that family treatment court would be a benefit for St. Croix County and allow for children to be placed back with their parents sooner, which in the long run will help the taxpayers because foster care is expensive. And so if kids can be moved out of foster care even 3 months earlier, that would be a huge savings for the taxpayers.
Thank you. Any follow-up?
We didn't really touch on the criminal diversion program that we have through the district attorney's office. And folks, we get calls where people complain, why this person get a diversion? It's typically someone who hasn't been in trouble before. We do what's called a compass assessment if they have to come back as being low risk in order to usually qualify for the program. But what it is most of the time it's a contract that folks sign saying they're going to do certain things. They enter a plea, they say they're guilty, but they don't get convicted. And if they jump through all the hoops in their contract, then their case could either be dismissed or reduced or whatever. On the other hand, if they don't do what they're supposed to do, and this happens occasionally, we have a hearing where we explain to the judge they didn't follow what they're supposed to do, they get revoked, and then we sentence those folks. There's no trial. So diversion programs give folks a chance. If they screw up, then they face the consequences. It saves us the cost of a trial and other costs. So.
Thank you. Any other follow-up comments or questions?
Well, and I guess just to add on, with regard to those diversion programs where it's either they can enter a guilty plea, and then the judge can say, we're not going to enter the conviction. So the guilty plea is already there, and then they sign a contract, as Brian said, and it has usually several conditions, and including going through an assessment and then following through with any classes that are recommended. If they don't do that, then they're back appearing in front of the judge. And sometimes that's necessary to revoke that, and then they will be convicted then. There's other times where it's pre-conviction, and it's just, we're not going to prosecute this further because you are low risk, because you have not had prior offenses, but we want you to go through, whether it's anger management or whatever mental health classes or drug assessments they need. And then if they're successful, then they don't even have to be back in court and enter a plea or do anything like that.
Okay, we are going to move on to question 8. Advocates for cash bail reform argue that there is significant wealth inequality regarding trial detention. Cash bail can disproportionately affect low-income individuals who are unable to afford bail. Critics of cash bail reform believe public safety is jeopardized when those accused of serious criminal offenses are released with no bond. What is your view on this issue? And we'll start with Gino.
All right. Well, bail reform has been, in the news because of primarily the incident that happened down in Milwaukee with the parade and a person who was out on bail and then committed a terrible crime, tragedy. The bail is outlined in Chapter 969, and it contains standards. And bail is only supposed to be used where necessary to assure the defendant's appearance in court. But when we had that referendum not long ago, there was more emphasis being put on protection of the public. And so you have to look at, it's a totality of the circumstances standard. You take into account whether the defendant had a prior conviction for a violent crime, the probability the defendant will fail to appear in court, the need to protect members of the community from serious harm, the need to prevent the intimidation of witnesses, and potential affirmative defenses of the defendant. So there's lots of conditions or consequences that the judge has to look at before setting bail. Now, the amount of bail is one thing. Yes, there are people that are indigent, and if you set it at $1,000, you might as well set it as $1 million, because they're not going to be able to come up with that. But you have to take every case on its merit, and I think you can't just blanket say we do away with cash bail or that there's some real high standard before cash is used, because cash is only one aspect of bail. There's many other conditions that judges can put on bail. They can have a condition that they have to maintain employment, a condition that they report to the jail and give urine for analysis to make sure that they're not using, or you can put no contact with certain persons, so you can protect witnesses by putting these conditions on, but you got to look at the person's record. Again, somebody that has a history of intimidating witness, that's not going to do any good putting intimidation of witness, and that's somebody that you would have to give a higher cash bail. So I don't know that there needs to be any reform. I think it's just judicious use of what we already have in Chapter 969, and and enforcing that on a consistent basis, not just in one branch, but across all the branches of our circuit court. And I think our judges do a good job of that.
So in regards to bail reform, I think the legislature recently passed a law in 2023 that helped this issue. So prior to 2023, judges were only allowed to set cash bail to ensure that the defendant would return to court. And in 2023, there was changes on how the judges are able to set bail. And so that allowed the judges to now look at prior criminal convictions, and other threats to the community, as Jamie indicated. So I think there is already reform that has happened in the recent last 2 years that have helped judges be able to determine what is the appropriate amount of bail for the defendant. I also think that with the county having a justice support services, there's been a lot more tracking of pretrial defendants. So if someone is released on a signature bond, let's say, Justice Support Services is the entity that can track those individuals while out on release pending their trial date. So some defendants have GPS monitoring on them, especially if they have limitations on where they can be. Some of the alleged crimes that involve drugs or alcohol require them to test frequently, not at a set date and time, but sporadically to make sure that they are not using as a condition of their bond. I do believe that the change in 2023 that allows judges to look at prior convictions, if there was violent crimes in the past, that has really helped judges to know what to do in their discretion when setting bail. I don't think we can go to a system where it's either no cash bail or just being held. Although there is a disproportionate effect on low-income individuals, I don't think changing the bail statutes to say no bail at all would be helpful. I think that would be harmful to the community in some situations. But there are some cases where someone's on $250 cash bail, and because they're homeless and jobless, all their family can't help them anymore, they'll sit in jail until their trial. And so I think that is not the greatest policy either. It's costly to the taxpayers and if the trial doesn't happen for 9 months to a year, they could sit in jail for longer than if they would have pled guilty from the outset. So I do think there's maybe some changes that could take place, but I think that's for the legislature to decide. I think committees would need to be established, experts in this area that have had years of experience to determine what legislative statutory changes would be necessary.
Well, I deal with this issue on a daily basis at intake court. We make bail recommendations to the judges. The judges don't always agree with them, but we just don't make things up. We look at prior history. Heather mentioned Justice Support Services. They sometimes give us a pretrial assessment report that gives a little bit of a history for certain defendants, how many times they've missed court in the past, how many times have they been convicted, have they been to jail. There's a little grid that has a risk level on it and a recommendation for level of monitoring. So when we recommend cash bail on someone, it's because it's necessary. What ends up happening is for folks that either get a signature bond or they have cash that they post and disappear, sometimes we don't find those folks for years, especially if they go out of state. And most of the time it happens to be Minnesota, and eventually they get picked up and sent back over here, but sometimes it's California or Florida, or we had a gentleman in Colorado. And so it's difficult for our folks to find these people once they're caught. Do we want to go to the expense of bringing them back? I mean, depending on what the case is. I mean, it's hugely expensive to transport, extradite folks from other faraway states. So those types of considerations go into typically someone who's got a $250 cash bond that he can't post. It's because he's missed court 6 or 7 times already. It's not because we just think it'd be funny to make him sit in court for $250. This is someone who is a serial non-appearer, and we have to give them something because we can't keep the case going indefinitely. I mean, folks don't realize the judges have to keep track of how much time they're spending on a case, and there's some oversight there. So we can't just leave cases run for years and years because people disappear and don't want to come back to court. And virtually every single day we get a call or a fax or something from someone saying, my car won't start, I can't make it to court. So if we just let those folks not come to court, nobody would come to court. So we have to give them incentives to come back to court, and that's cash bail is a good incentive in some cases. I do think that the law change that Heather was talking about was fantastic. It removed handcuffs from our judges to consider high cash bail for cases, homicides, child pornography cases, I mean, horrific cases where the defendant may not have any prior record. And so the argument we hear is, Well, he doesn't have any prior record, he's not a danger to the community. This is a horrific case. And I think with the change in the law, the judges can consider the charges in the history of the defendant in deciding what the bail is. And I think that's been very, very useful. And as a judge, I would certainly be using that tool.
And I would just add that, you know, every defendant too, their circumstances are going to be different, but if they can't afford a cash bail, which is required because of their past history, the violent nature or seriousness of their offense, or a prior record of bail jumping, it's called, it's an actual additional charge, it's another 9 months in jail if they were to be convicted. So those people some can request a speedy trial. Everyone has a constitutional right to a speedy trial. It's just become so standard for people to waive that speedy trial at a very early stage in the proceedings. But usually you've already set the bail. And so if the bail is set, the attorney, if they have an attorney, again, will know whether or not this person is going to be able to post that bail, and then can insist on a speedy trial if they have to.
Thank you. We will move to question 9. Judges have the authority and discretion to maintain order in their courtroom. Order might require someone to be on time, turn off their cell phone, or refrain from acting out, yelling, or being rude or unruly. What expectations do you have for your courtroom, and what would your general philosophy or approach be when it comes to handling a situation when someone is being disruptive? And for this, we will start with Heather.
Sounds good. So my expectations for the courtroom would be that anybody in the courtroom needs to be respectful to anybody else. And so if that includes the clerk, the court reporters, the bailiffs, the court services deputies, opposing counsel. I think respect for the courtroom and the institution of the judiciary is important. So I would require that people, have their cell phones turned off, don't chew gum, take their hats off, all the things that our judges in St. Croix County do right now. I think it's important to create an expectation that the judge is in charge of the courtroom and that people are to respect the judge and the judge's authority. I think you can do that in a positive manner without yelling or threatening to someone to be in contempt of court and sentencing them to jail for that. But I think it's important to set those expectations right from the get-go, making sure that people that come into your courtroom are respecting the judge, respecting all others, and if they aren't, to make sure their behavior stops. And whether that is, giving them a stern lecture or having them removed from the courtroom because of their disruption, I just think it's very important for the judge to exert their authority and ensure that the judge is in charge of the courtroom and no one else.
And Brian, we'll go to you next.
We have disruptions in court every day. I mean, there's no getting around it. We have people that are disgruntled, people who don't like their bail, people who don't like their sentence, family members of folks that don't like their sentence. For the most part, we don't have people being disruptive unless it's a serious homicide case or something like that. And sometimes we know ahead of time because we'll have family members that say, I'm going to attack that person when I get a chance. So we let court services, our officers, know you have to be very, very diligent in this particular hearing because we know that there's very, very high emotions. I had an intake with Judge Black one time where a guy just walked in and started yelling. And it wasn't about any case that was going on. He just started yelling because he was mad at the world. And so they whisked him out. I never caught what his anger was about. So it just happens. It goes with the territory. One thing that has happened in the last few years that I'm grateful for is that we now have security at the door with a metal detector to make sure that we're not going to have somebody come in and, pull out a gun and shoot a judge or a prosecutor or whatever, because there was a case at one time where a guy managed to get a knife into the courthouse. And I remember it very vividly. And so there was at that point, I think, some concern for danger to the court and the staff. But with our new security procedures, well, not new, they've been around for a few years. I think that's been very, very limited. I think that For the most part, our court services officers know who the troublemakers are, who are the folks that, may have mental illnesses or have grudges. I know that we keep pictures of certain people up around the courthouse, so if they come in, we can, be careful around them. But as a judge, if it happens to me, I'm gonna do what Judge Black does, and that is throw them right out of the courtroom, and if they don't wanna go, have a court services officer take them out. And Judge Black's courtroom, there's a door that goes right into the holding cells, so not all of the judges' courtrooms have that, so they can get yanked right out and put into a holding cell, and I've seen it happen many, many, many times. There's no room for disrespect. Being a judge is a very, very difficult job, and you have to make very difficult choices, and not everybody who appears is going to be happy with those choices, and typically, there's gonna be someone who wins and someone who loses, and there's just no way to make everybody happy in any kind of case. So you have to learn to live with that, you have to learn to recognize it, and you need to make sure that you deal with it quickly so that it doesn't turn into something worse. So.
Yes. Well, if I were the judge, my expectations for litigants is to be on time, be prepared, dressed appropriate, and ready to address the case. Now, the behavior that happens after that includes, talking when spoken to, and not interrupting, and not talking over the top of other people. This is not an ego thing for the judge. This is about efficient and effective administration of justice. So that's why those things are enforced. And judges do have the ability to find people in contempt of court, and they can be put in cells, as Brian mentioned. But they also can have their case, if they're in a court calendar where it's intake court, they could have their case be put at the back, and they can sit there and think about their behavior. If they're not gonna comport themselves, then their case won't get heard for the next 45 minutes or another hour. Sometimes people but it's not just pro se litigants that can be disruptive. It can be lawyers as well. And I would not condone badgering of witnesses. I would not condone attorneys who address each other rather than the court, because when they're in court, they're supposed to be addressing the judge, not getting into personal, tit for tats with each other. They need to be respectful as well. And sometimes attorneys get caught up in the emotion of the thing, but the court has to be as close to unemotional as possible, and in order to have effective and efficient administration of justice. But when it comes to expectations in the courtroom, it's not just what the judge expects the others, it's what you would expect from me. And what people can expect that would be appearing in front of me is that I will listen respectfully to them and give them a fair opportunity to be heard, and that I will be prepared when I'm in court. There is nothing that a lawyer or a litigant hates more is when they go prepared for a hearing and they go to the court and the judge says, I haven't had time to read the materials. I'm going to read the materials. I am going to be prepared. In fact, I'll be prepared to render a decision unless something the attorneys say causes me pause or causes me to change. There was Judge Wing in Pierce County when I was a young attorney. I got used to the fact that he was ready to rule when we were there. So I think that expectations are a two-way street. It's not just what the judge expects of the lawyers and litigants in front of him or the participants. It's what they will expect from the judge.
Can I? Yes. I think it also depends, the judge's approach to dealing with someone who is disruptive also depends on the case type and why the people are there. In handling mental health commitments and guardianship cases where people are deemed incompetent or they have a developmental disability, sometimes the people can't control their behaviors and the way they're acting in court. And I see it with our 4 judges that we have right now. They approach those cases differently because they know the person is not purposely being disruptive. It's because of their diagnosis, it's because of their situation, that they're not purposely being disrespectful to the court, but that might be their developmental disability or their incompetence or their dementia. So I think it does matter what case type the judge is handling and how they approach someone being disruptive.
Wonderful. Yeah, I think we'll move to question 10. In the state of Wisconsin, there is a backlog of felony cases. What role, if any, does the judiciary system have in reducing this backlog in case cases are decided on an annual basis? And what strategies do you feel could help reduce this backlog? For this, we will start with Brian.
Well, and again, I see it every day. There's lots of different factors that cause us to have backlogs of cases. People not showing up is one of them. That's a big one. Sometimes, and people don't generally know this, but on a busy court day, we'll have hearings scheduled every 15 minutes at some point. So if someone's late, or if the hearing before goes long, that knocks the whole calendar down for the day, and then eventually stuff gets taken off because we just don't have time to get to it. So there's a great need for handling criminal cases with efficiency. And we can't have a situation where the judge isn't ready to go. That it just can't happen, and it doesn't happen with the judges we have here. We're very lucky. We have to have folks that are going to show up, be on time, so we can stick to our schedule and process our cases. For the people that disappear, move to another state, and we finally catch them, part of the reason to give them a cash bail is so we can finish their case and get them a speedy trial or whatever. We have a lot of cases that sometimes get referred that are not cases where someone got arrested. It might be contractor theft or something like that, where the police decided not to make an arrest. So those cases tend to get put on the back burner as far as charging goes, because we're dealing with the cases where we've got people in jail on a daily basis. So the main thing I think that we can do is try to stick to our calendars, maybe work in some spare time so that when there is those inevitable delays, that we've got breaks that are built into the system so that we catch back up. And virtually all of our judges are pretty good at doing that, and that would be something that I would definitely want to do. The other thing is, ever since COVID, we've had folks appear by Zoom if the court gives permission, and some judges like it, some judges don't like it. I'm going to be a judge who likes it, because if I got someone who's calling me at 8:30 and says my car won't start, and he's got court at 1 o'clock, I'd rather have him show up by Zoom than not show up at all, so that we can keep the case moving. The other issue that causes a backlog, and this isn't anything that can be solved by the judges, is that we don't have enough people to take public defender cases. We frequently have defendants that come in and say they've called the public defender for an attorney, and there's nobody to appoint. Nobody will take the work. So we've got to deal with that. That's a big issue. We can't do the case if the person doesn't have an attorney. So we need to, I think, divert some more resources probably to the public defender office as well.
Thank you. Heather, we will move to you next for this question.
Sounds good. So I do think the judiciary does play a role in reducing the backlog. I think there are strategies that, as a judge, I would make clear expectations for both the district attorney's office and any defense counsel regarding timelines, making sure that the attorneys are prepared and ready to go when there's a hearing. If there's a motion hearing, items need to be filed. I think it's important to just set those expectations clearly for any attorneys or pro se individuals that appear before the court. If you have those clear expectations and timelines, hopefully the cases can be resolved quickly. I say that in quotes. I think that recently, when the legislature increased the wages for both the district attorney's office and the public defender's office, that helped with recruitment efforts for retention in those offices. With COVID, there was quite a backlog of cases. The Supreme Court of Wisconsin recently reported that 26 out of 72 counties have resolved some of those backlogs, but that still leaves a lot of counties out there that have backlogs of criminal cases. So I think the main thing is just the expectations in the courtrooms. Some things, as Brian indicated, you can't control. You can't control when defendants don't show up. And you can't control if a witness isn't available. But making sure that all attorneys that are before the courts have their timelines written down. They know motions need to be filed by a certain date, as long as it's within the statutes. That would help ensure that backlog is reduced. I also think that it's important that cases are resolved as quick as possible, especially when there's victims involved. Those victims, they were affected by the alleged crime, and the longer those cases go on, the harder it is for that victim to have closure. So I think just understanding as a judge that there is a victim involved in most cases, and that victim also needs closure. The defendant obviously has rights that have to be met, but just setting those expectations right from the get-go, I think would be important to help reduce the backlog.
I just want to toot our horn a little bit, because during COVID, almost all the counties in this neck of the woods quit doing jury trials. We did not. And Judge Nordstrand, who's here, had his courtroom modified so that the juror chairs were farther apart, so that we were social distancing, but we still did jury trials in that one courtroom. And I did the very first jury trial during COVID with Judge Nordstrand, and we all wore masks, and we had people separated, and it was awful. So I hope we never have to do that again, but we never did. We never stopped. We did have a backlog because we only had the one courtroom that was modified to be used for trials, and it took a long time to get through that backlog, but we never stopped. And other counties are still working on catching up because they just stopped having court altogether. So,
Do I get to answer that question? Yes. Okay, all right. So, yeah, it is true that when you say there's a backlog of felony cases throughout the state, that may be true, but as Brian pointed out, Zoom was an alleviant of that, if you will, helped, but COVID was the culprit in a lot of counties, but just not St. Croix County as much. It was very brief pause, and then it was getting back to trying to get back to business as usual. But there are lots of causes for cases to be adjourned, whether it's processing of evidence, witnesses not available, people not showing up. But I would say that making it ability for flexible appearances with Zoom, that helps. But I think holding the attorneys accountable is important. Judges are responsible for their caseload, and I've seen a fair number of times where the judges don't just necessarily go with a stipulation between the attorneys. Yeah, let's just push this off another 45 days. You have to hold their feet to the fire in the sense that what is the reason? And if there's a legitimate reason for adjourning the matter, then you grant it. But just having some type of standards, and I've seen some courts in some counties where they actually do printed scheduling orders, even for criminal cases. Now, stuff happens as we go, and then you have to deviate from that. But I think having scheduling expectations and enforcing that is what the judge can basically do. Now, we could always use more judges too, and we're going to try and get that fifth judge, and that would help any kind of, but we don't have, in my view, a serious backlog in St. Croix County.
Thank you, and my apologies for
That's
messing
right.
up the order there. Too many notes in front of me. Looking at the time, we are going to move to question 11, and that will actually be our final question before we move to closing statements. And I think this might be a lovely one to end on. So, is there a particular attorney or judge who you look up to or admire? Tell us who the person is and what you respect about them. And for this, we will start with Jamie.
Yeah, thanks a lot. Thanks a lot. You know, because now if I pick one of the St. Croix County judges, you know, am I sliding the others? So I'm going to try and do this as diplomatic. I have great admiration for all the judges. I've appeared in front of all of them. And, but when it comes to Judge Vlack, I have a personal story in that shortly after he took the bench, my oldest, my stepdaughter, Alex, was in middle school. And there was a bus stop that was in front of a particular residence. We didn't know it, but this person at this residence was a flasher. And so he exposed himself to my daughter and made her a victim of a crime, and where she would have to be a witness and go into court. That was a perspective that I've never had because I've always been there as an attorney, usually as an advocate for somebody. To be there on the victim's side and to see the compassion that Judge Black had. I've told him that, I reminded him of that story. He didn't remember because he's handled tens of thousands of cases since that, but it had to be his first or second year as a judge. And he had a very creative sentence. He put that person on probation and sentenced them to jail and so forth. But I really admired how he dealt with that case. And all it took was one phone call to the school district and that bus stop got moved. So it wasn't in front of that residence anymore. But I think I hold in high regard the judges who are prepared, who have standards that you can expect and they enforce. And for the most part, I've seen that in all our judges, but that ability to have empathy and compassion for the victim and to be fair when treating the defendants and the parties, I would say that's a quality that I saw in Judge Black.
Thank you. Brian, we will go to you next.
Well, all of our judges are great, and I think it's fair to say that they're all friends of mine. I get advice, and I am very grateful for the judges we have. I also have a Judge Black story. It's a little bit different than Jamie's. So when I first moved here in 2003, I opened my office in Baldwin. I was a sole practitioner, just trying to, make enough to pay the rent and trying to get folks to come in. And I had sent a letter to all of the sitting judges at the time and just said, hey, this is who I am. I got this office. I've got experience in criminal defense, family law, guardian ad litem type stuff. And the very first judge who reached out to me was Judge Black. And he called me up and he said, hey, what's your background? I told him. He's like, I got cases. It's back in those days, and I don't know if they still do it as much, but the courts would appoint attorneys for cases for people who were not considered to be indigent. You didn't qualify for a public defender, but you couldn't afford your own attorney. So the court would appoint an attorney, guarantee payment, and then the person would get a break on the fee, and then they'd have an attorney, a private bar attorney. So Judge Black, he was the first judge to call me up. He said, I got cases, come on in to my office. I went. He gave me one case, see how I did. I guess I did okay because he continued to give me cases, and then eventually the other judges did too. But he was the first one to take a chance on me and appoint me to a case, and I'm very, very grateful for that. And he knows the story. We talk about it occasionally. So he'll be missed. He just will.
And I have to agree with both the candidates. Obviously, all the judges in St. Croix County have a different relationship with each of them. They are all great with providing advice. But my particular attorney or judge who I look up to is my good friend Elizabeth Roll. She is the judge in Pierce County. She and I worked together from about 2015 to 2020 when she was appointed to Pierce County as their judge to replace Judge Bowles. I learned a lot from Judge Roll when she was an attorney. We worked closely together in all case types in our office, in the Corporation Counsel office. I learned a lot about evidence and trial prep. She is a big advocate of trials and loves to do trials when she was an attorney. So she taught me a lot about the practice of law in terms of how to present evidence and how to read the jury instructions first when you're prepping for a case. So even though I had been attorney for several years, working with her those 5 years really helped me in my career and becoming an attorney, and I credit her for my role now as Corporation Counsel. And obviously now she's judge in Pierce County, and from what I've heard, I've not been before her, but what attorneys say about her is she runs a good courtroom. She is prepared. She allows people to appear via Zoom if it's warranted. She has, expectations for scheduling and when things need to be done. And when you're a judge of a one-judge county, you have to run a tight ship to make sure things get done. And so I do really admire her and look up to her. She's one of the people that has endorsed me for this position. So that is who I look up to.
Thank you. And we will move to closing statements. Looking at my clock, it's about 7:35, which is just about at 90 minutes from where we wanted to be. By drawing we drew before, closing statements will start with Brian. You will go first. followed by Heather, and then Jamie, you will go last. You will each have 3 minutes to let all of the voters here tonight and watching online know why they should vote for you for judge. So, right.
Thank you. So my experience is unique, and I've given this speech before. I'm the only candidate that's been in private practice. I spent 15 years as a private practice attorney. The only candidate that has that experience, along with being a public defender and a prosecutor. Those 3 different career paths basically have given me experience in a huge variety of different situations, from both the defense and the prosecution side. I've handled many civil matters, family court, business disputes, personal injury, anything you can imagine over the years, I've done. I made the decision in 2012 to devote my career to public service. I've done that ever since. I will end my career in public service one way or another. But the experience I have had on a daily basis for the last 22 years in St. Croix County has been specific for this job. People don't generally realize that about 70% of what our judges do on a daily basis is criminal law. And the statistics change from year to year. And if you add in traffic offenses, which we also have to deal with, it's even more. We have other types of cases. We have family cases, and we have civil disputes and personal injury lawsuits. Much fewer of those than the criminal cases. In the criminal cases, there's urgency involved because we've got folks that are on bail that have speedy trials. We got to keep the wheels running, and we need a judge who's familiar with that process, that knows how the procedures work, can make quick decisions with regard to specifically bail, decisions on motion hearings, preliminary hearings where we have to decide if there's probable cause. I've been doing that work for 22 years, and every day I've been practicing for this job. And so I'm asking you to vote for me. My experience is unique, and I think it is the best for the job, and thank you very much.
So I would ask the St. Croix County voters to vote for me on February 18th and hopefully on April 1st. I think that my knowledge and experience working in public sector for 22 years is perfect for the role of judge. I think starting my career as a legal assistant and really understanding what that basic role is with the legal system, and then working my way up to assistant corp counsel and then the corporation counsel has allowed me to gain the knowledge that I would need to be the next judge for St. Croix County. Oftentimes, our cases in the Corporation Counsel office are very quick-paced. Mental health commitments have to be started and resolved within 14 days. So I know how to get cases resolved quickly. I know how to act on my feet as the parliamentarian and legal counsel for the county board. I'm required to do this weekly. I am a very hard worker. I think those that know me know that I'm a dedicated and passionate public service employee. I work hard every day, even on the weekends, as my colleagues will tell you, to make sure that the work gets done in a timely manner. And I would continue to do that as the next St. Croix County judge. While I don't have as many years of experience as Brian and Jamie, I believe my experience that I do have is directly related to the role of judge. I understand the county services that are available to people, whether it's a criminal defendant and their mental health needs or someone that's going through a guardianship case. And that knowledge I've gained through my 22 years of service in county government. So I would ask the citizens of St. Croix County to vote for me. Thank you.
All right. I want to thank again the city and the library for putting this on, but I think you look at the qualities that you want as a judge, and I believe that I've demonstrated those. First, you want somebody who has been dedicated and hardworking, and I've been hardworking my entire life, as I indicated, starting from working a farm and then going to school. And when throughout college and law school, I had jobs while I was going to school. And now, when I was a prosecutor, I had my boss, who was the DA, he came into my office, he said, I got to talk to you about something. He says, you're taking on too many cases. You have to slow down. You have to give some of those cases to the others, because I was taking on too big of a load. And, but then I went into private practice, and I'm used to doing 50, 60 hours a week. And on top of that, as my number one job of being a shareholder of a law firm, is being on school board and being president and putting in many hours on that. And then on top of that, community service. So I am a person who follows the tagline of our law firm: we get things done, and I will get things done as a judge. Judges are public servants, and I've had dedicated decades of community service, as was mentioned before. I think being a judge will just be an extension of that community service. Integrity and honesty and candor. I was once told by a top trial lawyer who's well known in this area. If I said his name, you'd know who, you'd agree. But after we had concluded a contentious case, he said, "Jamie," and this was when I was in my early 30s, "Jamie, you are a great attorney, but your biggest flaw is you're too honest." And when he said that, I took that as a badge of honor, and I've worn it ever since. And I have safely guarded my integrity and my honesty as my number one and two values that I always carry. So I will carry those to the bench. And you will see that I will be competent and knowledgeable. I've demonstrated that as well. And being fair and nonpartisan. I am very proud that I have attorneys who have opposed me in the courtroom, and they are my strongest supporters. And they are the ones asking me to be mediators in their cases. And I'm also proud of the fact that my campaign has been supported by Republicans and Democrats and independents, because we have to be a judge for all people, not partisan. And so I just ask for your vote and allow me to be your next public servant on Branch 2 in St. Croix County Circuit Court. Thank you.
Thank you very much. And this will conclude our forum tonight. I once again would like to thank the City of Livingston and the Friday Memorial Library and staff that helped put this on. And also to all of you for being here tonight, for anyone who is joining us at home, for your civic engagement and participation. We greatly appreciate all of you. So thank you all tonight for being here. We are finished.